We will call to order the Board of Election Commissioners of the City of Chicago, constituting ex officio the Electoral Board to hear and pass upon objections to nomination papers of candidates for the offices of Mayor, City Clerk, City Treasurer, and Alderman in the City of Chicago. Good morning. My name is Marisel Hernandez. I'm the chairwoman. Seated to my right is Commissioner Kresse, and to my left is Commissioner Jonathan Swain. Next on the agenda are motions. We don't have any. We have next Rule 20 hearings. The first one is 19 EB ALD-078, Joan Hollingsworth versus Matthew Roney, candidate for Alderman, 43rd Ward of the City of Chicago.
Here for Mr. Roney.
And here for the petitioner objection.
Okay, if you could just have a seat. And again, state your names for the record.
For the record, Adolfo, A-D-O-L-F-O, Mondragon, M-O-N-D-R-A-G-O-N, although Mondragon, the English pronunciation is fine as well. And I'm here for the candidate, Mr. Roney, who, by the way, is present here today.
And Adam Powers for the petitioner objector, Joan Hollingsworth.
Okay. And Mr. Mondragon, you're the one that filed the Rule 20?
I did.
Okay, well, I'll let you proceed.
If I could have one moment, just for the
Sure.
record. Thank you.
Take your time.
Good morning, board members, opposing counsel. Again, my name is Adolfo Mondragon. I'm here for representing the candidate, Mr. Matthew Roney. May I please this board? This Rule 20 motion is an appeal of the hearing officer's findings that candidate's Rule 8 motion was untimely. So the sole issue here pertains to the timing provisions of this board's Rule 8, specifically whether hearing officer Tedesco misconstrued those timing provisions and ran afoul of the plain language of that rule. Now, the facts of this case are very brief, they're procedural in nature, and they're uncontested. So I will walk through them to illustrate what our candidate maintains was the appropriate way of reading and applying that rule, those rule provisions, and then demonstrating how and why Mr. Tedesco's interpretation was wrong. So this board on the morning of Thursday, December 20th, commenced a records examination pursuant to Rule 6 of the candidate's petition sheets. That afternoon, a status hearing was held in which both parties agreed to continue until the following Friday, December 28th. Now, Rule 8 CI1 is a triggering provision. It states that any party that wishes to file a appeal of the Rule 6 results must do it according to CI1 not later than 5 p.m. on the first business day following completion of the record examination. That is, the day on which the parties were notified of the results of the Rule 6 records examination. Now, the candidate in this case contends that the completion of the records examination pursuant to this provision occurred on Friday, December 21st, and as an indicia of that, we like to point you to Exhibit A, which was attached to the Rule 20 motion, which is a petition summary report that was signed by representatives of the candidate's party, the objector, and here it says county city representative, but I imagine it was of this board, which states, I quote, "I acknowledge the completion of the records examination at 12/21/2018 5:35:22 p.m. And it contains results which at that moment, at that time, indicate that the candidate had 31 signatures greater than the required minimum. The following day, pursuant to this rule, the objector filed a Rule 8 motion just before 5 o'clock. And I will note that at that moment, based on those results that were handed in on that Friday, the previous day, the objector had to file a Rule 8 motion in order to maintain its objection alive. But the candidate was not in the same position, for he was 31 signatures above the minimum, and therefore did not have a need to file a Rule 8 motion at that time, because his candidacy was firmly on the ballot at that point. A few days later, on Wednesday, December 26th, both parties received an email with a copy of the final results, which is Exhibit B in our motion, which indicated that Mr. Roney, the candidate, in those subsequent days, had suffered a drastic reversal of circumstances, whereas on Saturday, the results indicated that he was on the ballot by 31 signatures. He was now off the ballot by 9 signatures. At that point, however, the deadline triggered by Rule 8CI1 had long expired, leaving Mr. Roney with the only viable road to file a Rule 8 motion with the rules CI2, which states that a party may file a Rule 8 motion, quote, by such other date and time established by the Electoral Board or the hearing officer. And therefore, Mr. Roney asked leave to file his Rule 8 motion pursuant to CI2 on that Friday, the 28th, at the previously scheduled status hearing. Now, the hearing officer, Mr. Tedesco, denied his instancer motion because he read and applied the rule differently. He found that the CI1 triggering provision triggered on Wednesday, the 26th, when both parties received the final results, and that on that date, the candidate had noticed that he was off the ballot, and therefore, pursuant to CI1, was obligated to file his Rule 8 motion no later than 5 p.m. the following business day, which was the Thursday, the 27th. But in order to reach that conclusion, we have to add language to the rule. Specifically, on CI1, we would have to read the rule in the provision that begins with, that is, the day on which the parties were notified of the final results of the Rule 6 records examination. I would point that the rule does not say final, it merely says results, and therefore the hearing officer's reading of this provision not only goes against the evidence demonstrated by Exhibit A, in which both parties and a member of the board sign and acknowledge the completion of the record examination at said time, but also state a set of results indicating that at that time, Mr. Roney was 31 signatures above the required minimum. Moreover, as an indicia that, in fact, the rule was triggered on the Saturday and not the following Wednesday, is the fact that the objector herself complied with the rule by filing her own Rule 8 motion, which she needed to file in order to keep her objection alive that Saturday, the 22nd, just before 5 p.m., indicating that she too understood the rule to have triggered at the completion on the Friday, the day preceding the results that they used to file that Rule 8 motion. And therefore, Hearing Officer Tedesco's reading and application of this rule went against the plain language of the rule itself, deprived Mr. Roney of due process, because essentially what it does is it punishes Mr. Roney for not having filed a Rule 8 motion that he did not need on the Saturday, the 22nd, but then preventing him from filing a motion pursuant to the rule to CI2, which does allow the hearing officer to grant such a motion when he did need it subsequent to the Wednesday, the 26th. And therefore, we ask that this board invoke Rule 8C I-2, which does mention the Electoral Board plainly, and grant Mr. Roney's motion, which is attached, Rule 8 motion, which is attached as Exhibit C to his Rule 20 motion, and remand this cause for further proceedings, including scheduling any motions in limine that may be needed, and of course, a hearing on the results of the Rule 6 examination. Thank you.
I just wanted to ask you, when did you file your motion then, after the 26th?
On that Friday, the 28th, at the previously set hearing.
Mr. Powers? Thank you.
Thank you.
I'll just be brief, and I'll note for the record that I would say neither attorneys or ministers are expeditious, and my father's a minister, and grandfather's a minister, so notwithstanding, I'll try to go quickly. Rule 8 is the only rule that's before this commission on time. It's pretty straightforward. Council would have you read an ambiguity into it that is just plainly not there. The final decision came on the 26th, to use council's words here this morning. On the 21st, the objector had 1 day to file a objection to keep his objection, to keep her objection alive. On the 26th, the objector, by the exact same language that he's used this morning, had 1 day to file an objection to keep his candidacy alive. He failed to do so. Waiting until the 28th, which was 2 days afterwards, is not expeditious. It's not in accordance with the rules. The rules are mandatory. This isn't a matter of several minutes or several hours that the filing was filed late. In fact, there wasn't even a motion for an extension of time or anything that was filed in advance of the hearing. All evidence presented at these hearings is according to Rule 8. Rule 8 requires a day beforehand. Before the hearing, it requires a day after when you have the results of the hearing. Neither of those, under any way to construe the timeline, worked here. And so we would ask that you would uphold all the findings of the hearing officer. We would adopt those as our own this morning. That's all I have. Thank you.
Mr. Nestor, do you have any thoughts here?
Well, I certainly agree with the hearing officer, Frank Tedesco, who's been handling these cases perhaps for 2 decades, for a long time. This rule has been uniformly and consistently applied in the manner in which Frank Tedesco applied it in countless cases. The flaw in Mr. Mondragon's analysis is that he's looking only at Rule 8. He's not looking at Rule 6. Rule 8 is actually all about Rule 6. Rule 6 expressly states right in it that the Rule 6 records exam includes those rulings which the records examiner's findings were appealed or reviewed by the handwriting expert and the expert's finding. Mr. Mondragon says that Mr. Tedesco is inserting the word final into Rule 8 by saying that it's the final results that trigger the rule, whereas Mr. Mondragon is reading the word preliminary into the rule. He's arguing that it's the preliminary results that trigger the rule. And the board's consistently strictly enforced this rule as well. There have been times when there are findings of good faith reason to extend the deadline, but I think that misinterpretation of the rule is not one of those good faith reasons for extending it. So I would agree with Mr. Tedesco's decision here, particularly because this board follows its own precedent. And if we excuse Rule 8 and the Rule 8 deadline for those people who do not understand the Rule 8 deadline, then we would never be able to enforce it ever again.
If I may rebut.
Oh, yes, please.
So the first point, Mr. Lasser notes that Rule 6 includes the handwriting expert's overwriting of the preliminary results. The candidate is not contending in any way that's not a process of the record examination. The candidate is merely looking at the language, which clearly says a set of results. Not final results, not preliminary results, results. And if we look at Exhibit A, it clearly is signed by a representative of each party, including this board, and it acknowledges not only a completion of the examination, but it provides a set of results. It doesn't say preliminary, doesn't say final, it says a set of results, just the way the language does. Moreover, I will note that Rule 8, unlike Rule 20, has that second provision, the catch-all, because it foresees that there are situations like this one in which the Rule 1 deadline may have expired, but there is a perfectly sound reason in which one of the parties did not file by that deadline, and therefore it establishes that by such other date and time established by the Electoral Board or the hearing officer. Whereas if we look at Rule 20, it does not have that accompanying provision, which indicates that this board understood that Rule 8 had to be worded that way in order precisely to be a catch-all for situations like this, where there may be a party that was not required or did not need, I should say, to file a Rule 8 because of circumstances on the date in which the triggering deadline expired, but soon afterwards, because of a reversal of circumstances, absolutely needed to, and that's what happened in this case. And that's why the Rule 8 has that second provision. All the candidate did in this case was he sought leave at the following status, which was a day after, to file instanter, mind you. It would not have prejudiced the scheduling of any Rule 8 hearing because it was instanter, but the hearing officer read this rule differently to avoid the situation in which the candidate was, and therefore made a conclusion that deprived the candidate of his due process rights.
Just to add to that, Madam Chair,
Sure.
he's acknowledged that there are two sets of results, that the rule's not specific as to which results in his eyes, yet he didn't timely file after receiving either of those sets of results.
Well, that was, I can understand, Mr. Mondragon, your views on this and your perspective, but I think in what I see is that if, at the very least, there was an email with final results on the 26th, then at the very least, there should have been a motion filed, that day, or but not, or the day after, but not on the 28th when you appeared before the hearing officer. I just don't see the merit of your position. I do think that, we have rules. Maybe this is a time to review the rules after this and make sure that they're clear. But this has been the way the rules have been applied. These rules have been applied. You make a great argument, but I think we still need to deny your Rule 20 motion and adopt the hearing officer's recommendation and report. Are there any further comments?
Mr. Lasker, so essentially, the objectors ruled 8 motion on December 22nd. Again, the rule doesn't say you can only file the day after. It's as long as that's the deadline. So it's, some observers might say he jumped the gun at this.
There have even been cases where one of the parties jumps the gun like that and then files a second one before the actual deadline, or an amended one before the deadline, and we've accepted that because it's, again, before the deadline.
Right. But the deadline is, 5 p.m. the day following the notice. So I think consistent with our precedent, we would have to, again, the findings of the hearing officer.
If I may, just for the record, an appeal, I would just like to note that the board's decision is contrary to the Exhibit A, in which all parties acknowledge the completion of the record on the Friday, the 21st, and that Exhibit A is in fact a set of results that nowhere in canon, in statutory interpretation canon, does it say that one must read in a word in order to make it accord with their argument. The candidate has not read in any words. It is the hearing officer that read in the word final results into the rule, and I'd like to note that as well.
Yes.
For the record, I would just disagree with the characterization.
So noted, thank you. At this time, if there's no further questions or discussion, is there a motion to deny the candidate's Rule 20 motion and adopt the hearing officer's report?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is hereby ordered that the objector's petition is sustained and the name of Matthew Roney will not appear on the ballot as a candidate for office of alderman of the 43rd Ward for the general municipal election.
Madam Chair, having entered a final decision, if I may, pursuant to section 10-10.1 of the Illinois Election Code, the commissioners will be signing these decisions today. They will be placing them in U.S. mail to serve on the parties, which then starts the 5-day clock for the time frame in which you may seek judicial review. That clock will start today when the decisions are placed in the mail. On the other hand, if you would like to stick around and communicate with our staff, they can provide you with the copy and serve it on you right here, right now today.
Yeah, we could sign it right now.
Thank you.
Thank you.
The next case is 19 EB ALD 126. We have a related case, 19 EB ALD 117. Raul Hernandez versus Byron Cicho Lopez, candidate for alderman of the 25th Ward. Is there anyone here in that case?
I'm sitting in for my colleague, Mr. Finkel.
Oh, okay.
Is that fine?
Okay. And Mr. Finkel represents?
He is the attorney of record who represents the candidate, Mr. Byron Cicho Lopez.
Okay, and,
Madam Chair, Mr. Finkel had advised me that he might not be able to be here because he's in another electoral board in the suburbs, I think.
oh, okay.
And Mr. Nally also was asking, he's actually at the same electoral board hearing. So it appears they're not here yet. If you could hold this case to the end.
Sure. I hope you don't mind. Thank you. The next case is 19 EB ALD-148. There is a related case, 19 EB ALD 123. Kevin Bailey versus Jennifer O. Maddox, candidate for alderman of the 20th Ward. Are the parties here? and please identify yourselves for the record.
Kevin Bailey, Kresse, objector.
Good morning, Madam Chair, Commissioners. I'm Michael Dorff, DORF, on behalf of the candidate.
Okay. And Mr. Bailey, this is your Rule 20 motion, right?
Yes.
Okay, you can proceed.
Thank you. All right, so we had our initial hearing on December 10th. That went well, and the candidate said that they would issue a motion to strike and dismiss, and he did. Motion to strike and dismiss consisted mostly of claims, allegations of bad faith, the claims of have first and signed signatures be stricken, and that objections to initiated signatures be stricken, and also that there was an issue with the blanks that were objected to. In the response and also in the hearing, well, before we proceed past his motion to strike and dismiss, his motion to strike and dismiss was mostly built on two cases that are not necessarily relatively applicable to the current case. The first case being Collins v. Davis, in which they identified that the bad faith was because they literally took photocopies from a previous objections petition and put them in a new one, changed the date, which is now nowhere close to what we have in our current case. Furthermore, there was no evidentiary support at all in the previous case, where in the current case, there was no evidentiary support in the Collins versus Davis case, where in the current case, Bailey v. Maddox, there was 319 out of the wards, 120 first-in-time objections, 19 duplicates, and in that case, in the case where Collins v. Davis, it said there was not even some of a inquiry put forth, and just those evidentiary points of support is well more than some. And it was also in the Collins v. Davis case, the bad objection, the bad faith objection was also coupled with a pattern of fraud, which is nowhere near the case, the current case that we have before us. Also, the other case that he references in his motion to strike and dismiss was, ultimately, they said there was no rule prohibiting dual objections, and that the hearing officer erred and the board sent it back for records examination. Furthermore, at the end of his motion to strike and dismiss, the candidate attaches Exhibit A, where it identifies page 28 on the candidate's petition sheets. It identifies that there are two signatures, both of which are objected to, but there are also objections going from 3 down to the end of it. But there's also in the far right category, says blank and it arrows all the way down. So we knew that it was blank. And when the hearing officer asked, why would you put objections in blank spots? I said, well, there was no deletion sheet accompanied by the candidate's petition papers. Therefore, we operated in an abundance of care. He said, really an abundance of care? He said, yeah. In the previous experience that I've had, there was a line scratch that was counted against me when I objected to a person in the previous case. So we operated in this capacity based on personal experience. So going forward, we did respond, and it was a very short case. And essentially, it seemed that the hearing officer erred in the fact that my objections, the hearing officer took small matters, mostly the respondents' unsupported conclusions of both fact and law, and translated those into unsupported conclusions of both fact and law matters into a monumental conclusion. The candidate did not provide any additional support or evidence supporting any bad faith allegations. They just supported an exhibit that I was able to identify from previous experience and on the sheet that we knew what we were doing and how we were operating, and that there was no deletion sheet associated with the candidate's petition papers. And for that reason, I filed the motion, the Rule 20 motion, to have the hearing reset so we can actually get the records examination. Thank you.
Mr. George?
Thank you. With the permission of the board, I'll stay here since this going to the podium is new for me. On behalf of the candidate, we support the hearing officer's recommendation. And we did not take lightly our filing of a motion to strike and dismiss based on the shotgun allegation. And it is relevant to note that in the related case that you mentioned, ALD 123, we did not file a motion to strike and dismiss. Obviously, we disagreed with the objection that was filed in ALD 123, but we reviewed the objection, we reviewed the appendix recapitulation, and they had apparently done some inquiry. They, in fact, had conceded 344 signatures left unchallenged. That to us is evidence that they did look at our petitions, and as I say, although we disagreed with the objections that they made, it didn't come anywhere near the standard of being a shotgun. And in fact, in the preliminary petition summary report that was issued on January the 6th, the candidate has ended up with 623 valid signatures, 150 greater than the required minimum. So we have gone through a record exam. We have had our petitions tested. This is not the case in the current situation. In the current situation, the objector objected to every single one of the 1,391 signatures that were submitted by the candidate. And I note that in the hearing officer actually found a page where one signature was not objected to, but even on that page, in the objector's summary page, objector listed that there were no valid signatures. What came out during the hearing, and the hearing officer bent over backwards as hearing officers should for pro se objectors, even pro se objectors who have done this many, many times and know how the system's supposed to work. What ended up being disclosed was that what the objector had done was candidate had 20 lines on a sheet. The objector started out by objecting to every line on the sheet. X, double, duplicate objections for registered and not genuine. And then had a little summary sheet that said, in the corner that said, number of valid signatures 20, number of objections 20, valid signatures 0. Then the only inquiry that the objector apparently made was going back to see where the blanks were. And when the objector discovered what the blanks were, they crossed out the X's they had already put in, and then they crossed out the 2020 0 and changed it to either 220 on the page we submitted, where there were only 2 signatures on the page, or they changed it to 550, and it's very clear that the cross-outs occurred. And these objections included an objection to the signature of the candidate. And the hearing officer quite rightly pointed out that all the objector had to do was look at the signature of the candidate against the signature on the statement of candidacy. And the hearing officer noted that there was not even an objection to the statement of candidacy, assuming that there was a forged candidate signature. Now, the objector has given many, many reasons for what they did, but the hearing officer then, on multiple occasions during our hearing on the motion to strike and dismiss, asked the objector, would the objector like to testify under oath and explain the care that was put into the objection. On each of those occasions, on each of those multiple questions, the objector said, no, I will not testify under oath. And the hearing officer quite rightly made the inference that this isn't a criminal case where you can take the Fifth Amendment. The hearing officer quite rightly made the conclusion that a negative inference could be put on the candidates refusing to testify under oath, where the hearing officer would have had a chance to ask questions, or I would have had a chance to ask questions to explain why all of the signatures were objected to. The objector makes much of Collins v. Day. And Collins v. Day, as we say in our motion to strike and dismiss, the premise that Collins v. Day makes, and the quote we have is that some inquiry is not the same as making a reasonable inquiry. That's the importance of that case. And some inquiry was what the objector did, was after objecting to all the lines on every single page, some inquiry was going back and seeing which of those lines after the fact was plain. That is not a reasonable inquiry. And as I've stated, we have already, the candidate has already been tested in 123, has had to go through a multiple day record exam, has come out on top. And it is inherently unfair to make the candidate go back in that exam for every single signature. And the hearing officer was quite right to say this is a shotgun done in bad faith. Shotguns are rare situations, but this is one of the situations that fits within the shotgun definition.
May I reply?
Briefly, yes.
Sure. So Mr. Dorff, nor the candidate was anywhere near the team that I have when we put these recapitulation sheets together. So
So why didn't you testify?
I actually had a couple witnesses there. I'm pro se. What I'm saying is on the record already. And I had portions of my team because during the whole trial, he kept saying, well, you did this or you did this, you did every single part. I'm a committee member. I have an entire team, one organization, and hundreds of judges. There's all types of volunteers that I have access to, and 2 were present and were not allowed to give their testimony. So why were they not allowed to give their own testimony? That wasn't up to me, that was up to the hearing officer. I'm already pro se. When I speak, it's already on record. So I didn't think that my further testimony talking about the same thing would make any difference, bringing up my additional witnesses who are part of the team, who did do a lot of the research, well more than a reasonable inquiry was there. And also, the objections that took place were not even close to the same. There are multiple types of objections. It wasn't the exact same ones on every single line. There are first in time, there are duplicates that we identified. There are out of the wards. All these come up to a culmination of what you see before you. But
you're telling me that you challenged all signatures but one.
no, as a matter of fact, I don't recall exactly the exact amount.
Well, that's
but
what the hearing officer says, and that's what Mr.
That's what the hearing officer said, and Mr. Dorff here just identified that there was no challenge to at least one signature. So just that one comment is inconsistent. I don't know how many off the top of my head.
Well, I think I'm relying on the hearing officer's report because there's no reason why the hearing officer would say anything but the objective truth. But Mr. Bailey, we take these cases very, very seriously and these petition challenges very, very seriously. You know, and when you're challenging, you cannot, without a good basis, and I just can't honestly see how you could challenge all signatures, virtually all signatures but one, on a candidate's petition. And I'm telling you, we are very serious that we are not going to delve into and cooperate with, what the hearing officer considers to be bad faith, has determined are bad faith objections. You have objected, you serve as objector to a number of cases now and previously. And you should know better than to engage in this type of tactic. And I agree totally with the hearing officer. I hope this is you've learned something from this. But you cannot engage in this type of tactic and take up the hearing officer's time. We're trying to get people on the ballot. We're trying to get a ballot ready. We cannot entertain objections, where every single signature is challenged. And after reading the hearing officer's report and recommendation, I totally agree with him.
Mr. Bailey, in the last few minutes, starting with Mr. Torp was speaking and then going on here, I have access to all of the, to your objections and to the recapitulation sheets. And yeah, every signature, somehow one got passed, was objected to. And as such, I cannot find that the hearing officer's recommendation was an abuse of his discretion or anything like that. I would have to affirm his recommendation as to these objections.
And with that, is there a motion to deny the Rule 20 motion and to adopt the hearing officer's report and recommendation?
So,
Is there a second?
second.
All those in favor?
Aye.
Motion passes. And, Mr. Lasker, is this the final case? Okay.
Oh, no,
Uh,
not
There's
It
still
is a
another one.
pending, and with respect to,
The related case?
candidate Maddox,
We're still awaiting
the other,
the handwriting expert's final
Okay.
report on
Yes.
123.
So.
That other case is pending, so this, we would just dismiss this objection. No ruling on validity of nomination papers.
Exactly, okay. But we do still, affirm, the hearing officer's report and recommendation.
Correct.
As was in the, okay, so that is correct. So the motion has passed, and, we will provide you with a copy of the decision, right now.
I think technically the motion was denied, because
Right,
the
the
Rule
motion's
20 motion was
denied.
denied.
The Rule 20 motion was denied.
The
and
motion to
hearing
deny passed.
officers-
Concur the hearing officer report.
And the hearing officer's report is adopted.
Thank you.
This is really for the public seat. Whichever table you want.
Let me take this out.
Ready? Next case is 19 EB MUN-004 and 19 EB MUN-008. We have a related case, 19 EB MUN-027. Shajan Kuriakosi, Harriet Mims, and Shantia Kimball versus Catherine Brown D. Tycoon, and Richard L. Barnett versus Catherine Brown D. Tycoon, candidate for mayor, city of Chicago. Can the parties please identify themselves?
Madam Chair, I have a question from council before you do. Because we dismissed these for warrant prosecution last time, we had a motion to bring it back forward.
They were not dismissed for warrant prosecution, but we did the decision.
Speak up.
We had thought that we were gonna have the hearing officer's recommendations served prior to the meeting, but they weren't. So, they were subsequently served. We're here on the Rule 20 to,
So we took no action last time? I thought we did.
no, we did,
Okay.
but it was premature. I was not aware at the time that we
All
were
right, so there's
not.
nothing else to do, we consider. Okay, that's fine.
Right.
Okay.
We are reconsidering.
That's fine.
And this is the candidate's Rule 20 motion and request for review. Ms. D. Tycoon?
Yes, good morning. Good morning, everyone. Like she said, my name is Catherine Brown D. Tycoon, and I wanted to just come and speak upon the two different cases that were sent to me. I had an issue with the objectors petition, the objectors' objections. What I didn't understand was, they said that none of my petitions were bound, and that I had them in too many books. When I read the rule stated that they needed to be in book form. I've been reading books for a very long time. And I realized that some books just have just pages, but there's also books that have chapters. And they're a complete book. And I looked at my volumes as chapters to a complete book. On the day that I turned in all of my petitions, they were all turned in as one set. One set. In the objectors' objection, they stated about different cases that did have more than one volume or chapter, as I would say. But they also didn't show you in their objection that each one of those particular volumes that they spoke about in the objection were sent at different times. For example, and I'm speaking of the case of ending in 004, when they were speaking about the different, how I had 17 books. According to the receipts that I received for my nomination papers, every one of them has a 9 a.m. stamp under one ticket number, meaning they was presented as one book with several chapters to the book. So I could not understand why would the objector say that they were not bounded when it clearly shows on my receipts that they all were. And according to the rule, they all need to be binded in book form and numbered. And they all were numbered. They all were taken pictures of from pages 1 all the way to pages 4,795. So I heard you when you said in other cases that we're trying to get people on the ballot, not off the ballot. Here we stand with 4,795 pages of registered voters in the city of Chicago who say, we want another opportunity to have another choice for mayor. Why is it that this objector chose to make it seem like to the board that I turned in additional sheets after the 9 a.m. recording? That never happened. every single one of my receipts at 9 a.m. with the very same ticket number, meaning it was turned in as one set. And as I said before, I've read many of books, and many of them have chapters. And they are one complete book. Why is it now the objector wants to say that this was not binded when it clearly says on all the receipts that it was? Why is it that the objector wants to say that we need to just go with the biggest volume, one volume, one chapter out of one complete book?
Well, let's hear from the objectors' counsel. Can you identify yourself?
Sure. My name is Doug Ibendahl, I-B-E-N-D-A-H-L. I'm the attorney for the objector, Richard L. Barnett. It doesn't look like there's anyone here from the other objector.
Right.
In,
He's not from the case.
I'm sorry, in MUN 004. With all due respect to the candidate, I would just say that the focus so far has been on the issue of the binding the petition papers in numerous separate volumes. In my client's objection, we actually did not focus on that. That was not our focus. That was not one of our objections. That was in the MUN 004. The focus of the Barnett objection was on the photocopied pages. That was the primary focus, and then also on the filing of the statement of economic interest. I actually filed a Rule 8 motion. I believe that the hearing officer's report in this case, or in my case, in 008, actually does not include a specific ruling on my Rule 8 motion. It's still out there, I guess, but the way I read the hearing officer's report is that was essentially mooted because of the earlier number of the other objection. The ruling in the Barnett objection largely relied upon, was largely mooted by the ruling in the other objection. And I do not have an objection or issue with that. But I would just, I guess my main point is that I respect what the candidate is saying about the difference of opinion about with the separate binding and the different chapters. That's a very good argument. But I would also say that there's more here. I think that I do not have it. It looked like it wasn't online yet when I checked last night. The hearing officer report in MUN 004, but from what the hearing officer included in her report, in my case, it does appear that the issue of the photocopy, my reading is the issue of the photocopy was considered, and then it was just mooted by the time we got to running up my ruling. I'm looking at page the findings and recommendation. There's indication here which hearing officer reviewed in the files, talking about the original nomination papers, and then on the second to last page, right before the recommendation, the finding was the binding did not meet the Section 8 standard. Further, it was found that failure to submit the nomination papers in the appropriate form resulted in insufficient number of valid signatures to meet the requisite 12,500 Chicago voter signatures. So in any case, I'm not here to pile on today on the candidate, but I did just want to note for the record that to the extent that the board didn't see the specific, preserve that for appeal if necessary, to the extent that the board did not see sufficient detail regarding the review of the photocopied pages. I wanted to be here to note for the record that I did file a Rule 8 motion on that, specifically asking for a specific, basically a limited scope records exam that just would be limited to the 4 corners of the nomination papers themselves. Thank you. But otherwise, that's all, and I would just ask that I think that with that, apart from that quibble, I think the hearing officer's report is absolutely right, obviously, and ask that it be affirmed and adopted.
Mr. Deacon, is this your first time running for office?
No,
No?
it's not.
Okay.
Let
Well,
me,
I'm glad.
I want to state this to the board as well. I appreciate, what he said, but I want to stick to 004 first. I want to finish one and be able to discuss the other, because it's like we tying the two together. And I didn't get an opportunity to kind of finish 004, which is the first case that we're speaking of, and then tap into what he's saying, because it's kind of, confusing. So I want to kind of stick to one thing and then get an opportunity to address the other. You understand what I'm saying?
Well, the issue I think is that the 17 different bound packets that you submitted as your petition pretty much is controlling over any cases, any objections that were filed, and your candidacy. And I just want to state that this is not our choice about deciding to declare that your candidacy is not valid based on the way you bound your petition sheets into 17 different packets. This is the Illinois Election Code that requires that it be done in a certain way. And although there isn't any specific reason stated in the Illinois Election Code, I believe it's for to ensure, to minimize any allegation that there was something improper, that someone slipped a sheet in or took sheets out, and that is the reason for requiring your petition to be bound in one document, okay? And so when you were trying to be as orderly, as possible and as organized as possible with your petition sheets, unfortunately, and even the fact that they did give you one number receipt as a receipt for the 17, we still have to look at the way it was bound. And we have no other option but to follow the law. I would love this election code provision to be changed, because I think it's unfair to people like you who are just trying to do it on your own without any legal assistance.
Well, the legal assistance that I had was the law that stated. And the law that stated says it has to be consecutively numbered.
Right.
So that way, just like you're
And
saying,
you
wait, hold on, just like you're
numbered.
saying, there was no way for anybody to slip in or out a number without the board being able to tell that. Because they were consecutively numbered 1 to 4,795. Now the board, at this point and at this day and time, they scan every single page. So therefore, they know that there was no tampering, there was no additional anything put into those petitions. And the law clearly states that they should be consecutively numbered, and they were.
Let me just weigh in here very briefly. I concur with my colleague. It's unfortunate that the law, we have to adhere to the law as strictly as we do with respect to this particular provision. I do agree with you. I think this provision as it's applied today is probably from an era previous when you didn't have to unbind them to scan them and to put them into a system. And so I mean, I would love to have this be looked at because I think it is a challenge to folks who are trying to get on the ballot at any particular point in time. But unfortunately, the law is very clear in terms of how we have to respond when petitions come in this particular fashion. Our hands are bound effectively.
Can you please show me where it says one higher? Please show me in the law where it says one, because it does not. It does not.
And so what I would say to you is this. Election law is something that is always taken to court to have things clarified. As you've heard here today, people are referencing cases that are long-standing kind of precedent that we have bound by. And as such, if there's a question in terms of your ability, your interpretation of that law that disagrees with our interpretation, I think that's where you can go yourself to circuit court and have that question raised. But I think, unfortunately, and I can ask counsel to speak more specifically on it, we're bound by kind of the black letter of what the code says. Am I correct?
Likewise, I am sympathetic with the candidate. I can only imagine the amount of effort that took place
Absolutely.
to gather all these signatures. However, like my fellow commissioners, we take an oath to uphold the Constitution, the state and the U.S. Constitution, and the laws under that, and the court rulings under those laws. And the courts have ruled that this provision of the Illinois Election Code is mandatory, and courts, both circuit courts and appellate courts, have ruled on it, some cases going back over 20 years. And they've found that in these cases, it has to be one volume bound together, and that if not, then the largest volume is all that we can look at. So because we have to uphold our oaths of office and uphold what the courts have said, along with the mandatory nature of the Illinois Election Code, we find ourselves in a situation where we, feel sympathetic toward the candidate, yet we are bound to follow the law.
And I appreciate you following the law, but I wanted you to show me the law that says one. Can you please at least tell me what that law number is, and where is it that says one?
Mr. Lester?
It's in 10-5.
Say it again.
Verify that.
Illinois Election Code 10-5.
Mm-hmm.
So, but the thing is, you're correct, that it doesn't say in one. It doesn't say that.
So how do
That's
we
what-
rule that?
Sometimes and often, laws don't say everything that they should say to make them.
But how do we abide by them if they don't say that?
Why don't you let him finish this?
We then have cases that go in the court system, interprets what did the legislature mean when they drafted that sentence that we can't quite figure out what it means. And so the courts interpret it, starting at the Electoral Board level when it comes to the election code. And then these cases are reviewable by the circuit court, the appellate court, and the Illinois Supreme Court. And so what we have to do is study the whole world of jurisprudence. We can't just look straight to the statute. We also have to look to the case precedent. And the fact of the matter is that on this particular issue, the binding multiple volumes issue, it was back in 1995 that this board did enter its first decision saying, well, wait a minute, these multiple volumes we think is in violation. The reason it said that is that the election code does say that the petition sheets have to be securely bound. And when you just interpret the plain language of what it means for the petitions to be securely bound, the courts have determined that means secure in one volume, because it doesn't say secure in multiple volumes that are not secured to each other. It just says that they have to be securely bound. The petitions have to be bound. Okay? The circuit court has affirmed the Electoral Board's decision on that from back in 1995. And And so that's what we have to do here. Also, you know, the case law on election law talks about modicum of support. That's one of the biggest issues about the restrictions on someone's right to run for office, is that from the United States Supreme Court on down, they've said that there can be reasonable laws to require a candidate to show a modicum of support from the community in order to get on the ballot. I was in that petition filing room when you walked in. You had a group of people with you, and you had a stack of petitions this tall. They were bound beautifully with front cover, back cover sheets with a spiral binding like this on every volume. It was abundantly clear to me, just from watching you walk into the room, that you had a modicum of support in the community, that you had worked extremely hard on getting these petitions done in a very professional-looking manner. And my heart kind of sank when I saw that, oh, these are all multiple volumes. I know the case law. You know, I used to work with candidates before they filed their nomination papers, and if I had been working with them, I wouldn't have let that happen. But I also have to point out that Mr. Ivindall, in his case, is also correct that on another technicality, the statement of economic interest was a fatal flaw. So that even if your petition sheets were all bound together in one volume, that technicality would have got you there.
No, because it was, I have a copy of it myself. He's totally wrong on that. He's totally wrong.
Okay, well,
I have a copy of it. It was filed in the right place, and it was a statement of economic interest. But of course, we're not speaking about that today, but I do have proof of that.
Well,
that
I
it
would
was.
say, if I don't want to use up any more of the time, but if one clarification on that, I would say the candidate's not completely wrong what you just said about my objection, but on the statement of economic interest, but actually the other one, the 004 case, actually objected, which I think is rock solid, that the statement of economic interest was the wrong form of statement of economic interest.
No, they did not put that in there.
Well, it ain't.
It's not in their argument.
Well,
Okay.
let me just finish. I'll actually agree with the candidate on something else. I don't think that the separate volumes was even the strongest objection here. We haven't even talked about it. It's the photocopy pages. Photocopy pages is the big problem with these objections. But beyond that, to support what the board has said, I would say that I did not think that the separate volumes was the strongest objection, but it does make sense. Obviously, I have a biased opinion here, but if the board allowed multiple volumes, let's say, so you've got 30,000 pages, let's say 10,000 pages, and you've got different chapters, different volumes with only 100 each. Well, if that was okay, then it's just a matter of time until some smart lawyer argues by analogy, well, if it's okay to separate 100 in a separate volume, then why is it one page in a volume? Each page is a volume, and so then you're left with they're not bound at all.
Okay. Well, I think that we've heard,
I would like to, I'm sorry.
just very, very briefly.
Okay, well, because I never got a chance to really address 008. We've basically been dealing with 004. My biggest issue with 008, with the photocopies per se, that never ever been examined anyway. And from my understanding, the objector should have examined the petition themselves. I talked to Mr. Barnett myself. This man is extremely sick. He did not do that. So why is it that we're here with
Because the separate volumes.
yeah, but I'm saying he mentioned
overrides
that.
everything.
Right, so I wanted to stick
Okay.
to that, but we talking about 008 and we here for 004.
But we're here for both. And in terms of both,
Mm-hmm.
the fact of the matter is that the separate volumes in your petition override anything else. And at this time,
Madam Hernandez, one more point, please.
yes.
Please. and then I'm gonna try to leave this where it's at. In you all's, on page 11, when you all have it online to show us how to present our petitions, on page 11, number 9, it says multiple filings. If multiple sets of nomination papers are filed for a candidate for the same office, the State Board of Elections, appropriate election authority, or local election official where the petitions are filed shall, meaning that it's mandatory, within 2 business days, notify the candidate. I was not notified at all that there was an issue with a multiple of filings. Why didn't that happen?
I'm not sure what,
There was only one certificate of nomination filed in relation to these in relation to these
So
petitions.
why are we here?
Robert, finish, please.
There were multiple volumes of petitions filed, but only one set of nomination. So that did not trigger, this is for a different situation in the law, where someone has literally filed one set of nomination papers with a statement of candidacy, a statement of economic interest, a loyalty oath, and the petitions, and a second certificate of nomination or statement of candidacy form for the same office. That's when there's actually 2 sets of nomination papers, not one set in multiple volumes.
I think we have,
He just proved my point though.
Ms. D. Tycoon, I
Okay.
think we've heard enough.
Yes, ma'am.
Thank you.
Thank you for hearing me.
Is there a motion to deny the candidates Rule 20 motion in 19 EB MUN-004 and 19 EB MUN-008?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
And at this time, I would make a motion to ratify the board's decision on January 2nd, 2019. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Thank you.
Thank you.
And really, it hurts me. I just want, it really does.
I believe that.
You did such a good job, and this is the result.
Well, just like
Okay.
everything was being exposed with Ed Burke,
That's right.
the rest of it will be getting
Yes.
exposed.
This job will sometimes break your heart. because we've done it.
It'll come out. I appreciate you though. I do, madam. And sir.
Thank you. Thank you.
All of them. Oh,
You have something to sign on?
No, because we ratified.
Oh, that's what we
we're
just ratified.
They will have copies available for you if you'd like to stay.
I'm sorry.
They'll have copies available.
think she handed you.
Oh,
Is that what she
she's just
handed
saying.
you?
Right.
Thank you.
I
all of them will be for one day.
The parties are here, are they?
No, I don't see.
Okay, I'm gonna just, I'm sorry, Mr. Moore, you're stuck. But if okay,
So,
Mr. Nally.
is it still on the call?
Yeah.
Yeah.
Let's wait.
We done?
I have communicated by email with both Mr. Nally and with Mr. Finko in
Representation wasn't even here. How did we even?
three-way email communication about that they both might not be able to make it. Please hold it till the end. Mr. Finko did say he might be able to have someone else step up.
So, have we come to the end?
No, no, no.
Still going, okay, thank you so much.
Okay. So, now, we will proceed to the, now we will proceed to certain subpoenas. The first one is 19 EB ALD-125, Andrea Hernandez versus Angela Clay, Alderman, candidate for Alderman of the 46th Ward. Mr. Lasker. I'm sorry, your name?
John Fox,
Candidate.
for the candidate.
Okay.
In this case, it was the objector's subpoena request, is that correct?
That's true.
The hearing, is anybody here for the objector? He did not ask us to hold this case. The objector timely filed a subpoena request on December 15th for 9 petition circulators, the notary public for those sheets, and for the candidate himself. The hearing officer finds that there was no statement as to the relevance for these the requested subpoenas. Nothing related in the objector's petition. He held ruling on it in the event that after an evidentiary hearing, perhaps something would arise that would make them relevant, but now he just recommends that the request be denied.
Okay. Are there any questions? If not, is there a motion to deny the objector's subpoena request is not relevant to the case and for lack of compliance with Rule 19C?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next is Nathaniel Moore versus Jeremiah Brown, 19 EB ALD 127, candidate for the 7th Ward.
The parties present? Seeing none, the objector filed a subpoena request on the 26th seeking the testimony of Shante Brewer, an individual alleged to have personal knowledge of the candidate's legal residence. The residency of the candidate is at issue in the objector's petition. This request was filed past the deadline of Rule 19, but the hearing officer points out and agrees with the objector that there was no way that the identity of this person would have been known. There was evidence new evidence that was created in the course of the proceedings that has raised issues involving this person. The hearing officer does think the testimony would be relevant and recommends granting this subpoena request.
Any questions? If not, is there a motion to approve the objector's subpoena request?
So moved.
Second?
Second.
All in favor?
Aye.
Motion passes. Oh. Next item on the agenda is consideration of certain hearing examiner reports and proposed final decisions. Mr. Lasker, are there any changes to this list?
We do have 2 matters where the hearing officer's recommendations actually were not quite submitted for today. We're going to move to the next meeting on number 20 on the agenda. It's ALD 084. And number 31 on the agenda, case ALD 131.
So that's 20 and 31. Okay, so
Mr. Nally's here, Mr. Mondragon, I think, stepped to the hallway.
okay, because if we can take care of this before we start on these cases.
Yeah.
Okay. Okay, we will recall 19 EB ALD 126. There is a related case, 19 EB ALD 117. Raul Hernandez versus Byron Cicho Lopez, candidate for alderman of the 25th Ward. Can the parties identify themselves?
Yes, good morning, members of the board. Thank you for your courtesy. James Nally on behalf of the objector.
Good morning. Again, my name is Adolfo, A-D-O-L-F-O, Mondragon, M-O-N-D-R-A-G-O-N. I'm sitting in for Mr. Finko, who could not be.
Thank you. And the Rule 20 motion was filed by Mr. Nally, the objector's attorney. Mr. Nally?
Yes, thank you, members of the board. This is a case where we're asking the board to review the recommendation of the hearing officer as to the issue of the residency of the candidate, Byron Sigcho Lopez. Mr. Agrella entered his recommendation on January 2nd in this matter. This decision, we believe, with all due respect, does not conform to the requirements of DELC versus Board of Election Commissioners. We believe that in this case, the hearing officer did not weigh the factors that are non-subjective factors, but objective factors regarding the residency of this individual. To summarize, I know you've had an opportunity to look at the written materials. This is an individual who claims somewhere around July 30th of 2018 to have established a residence at 1813 South Carpenter, which is in the 25th Ward in the city of Chicago. He indicates that he established a residence by moving some bags and boxes into a storage room in a second floor apartment in that building and sleeping on a sofa in that apartment for, by his testimony, the months of August and September, somewhere around 3 to 4 times a week, and then by the months of October, November, and December, tapering down to roughly 2 times a week. We believe that the objective evidence clearly shows that did not take place. A request to produce was served upon the candidate asking for the normal types of documents that would establish one's ties to a residence. He could not produce any of the following documents: a written lease, a driver's license, a state ID, car registration, tax return, pay stubs, checks, rent receipts, utility bills. The only claim he had was that he moved some boxes and bags into what was admittedly a storage room, not a bedroom, not an apartment. I think the strongest evidence here is the record owner of the property, Gloria Herrera, who's the landlord, testified that she never granted the candidate permission to move into the building. The second floor apartment was occupied by her sister, Martha Herrera. And Martha alleges that she had authority to allow Mr. Sigcho to move in there, but the facts are that she did not. She was a tenant of her sister. She never informed her sister that Mr. Sigcho was moving in or claimed to have moved in. In fact, probably the most telling testimony was when Gloria Herrera testified that she confronted Mr. Sigcho regarding his residence, or use of 1813 South Carpenter as a residence address on his nomination petitions, and he remained absolutely silent. The only mail that this candidate received at this address was self-serving political mail. He got mail from labor groups and from Act Blue. And again, he provided that address to these entities to send mail to that address. And a very curious thing happened about a week before our hearing. On December the 17th, a mailbox suddenly appeared bolted to the fence of this property with Mr. Sigcho's name on it. Prior to that, there had been no mailbox with his name. There had been nothing to indicate he had any connection to that address. And suddenly this mailbox appears out of the blue. We think that's clear evidence that the candidate at this point was desperately trying to provide some sort of an objective evidence that he was residing there by trying to have a mailbox with his name on it. I think another very important thing for you to look at is this individual ran for and was elected to the Whittier School Council as the community representative in April of 2018. Why is that important? It's important because in order to be a community representative, you must live within the attendance boundaries of that particular school. And Mr. Sigcho on the stand admitted that 1813 South Carpenter was not within those boundaries. Yet he further testified that he continued to serve not only after July 30th of 2018, but up through the present date of that hearing when he was put under oath on December the 26th. So very clearly, if he had established any residence, it was not at 1813 South Carpenter, because he would otherwise not be eligible to serve as that community representative on the Whittier School Council, which he continued to do up through the entire time he was claiming residence at 1813 South Carpenter. Again, one of the things that DELP teaches us is that you have to look at common sense, you have to look at what people do in the everyday course of their lives that would be consistent with a residency. One of the most interesting things here is Mr. Sigchow testified, and his wife did as well, that they were married on September 8th of 2018. His wife has a condominium unit at 20 North State Street in Chicago. Mr. Sigchow testified that he never cohabitated with his wife from the time of that marriage on. And his wife testified that she never stayed at 1813 South Carpenter from the time of the marriage on. Now again, one of the factors that is looked at in these residency cases, where does the family or the spouse of the candidate live? And his wife was very clear on the stand that she lived at 20 North State Street in this condominium and had for quite some time. Another interesting element of that is Mr. Sigchow said the reason he wasn't staying at 20 North State was he couldn't find parking. There's no parking. His wife testified that she had a parking space 4 blocks from her unit that she rented for $100 or $150 a month. So the idea that parking was unavailable was laid to waste by his wife's own testimony that she had parking nearby and had that for a serious amount of time. I think that...
Are you making a statement about what you do there as opposed to what?
I'm making a statement that these are factors you can look at. And I think that one of the factors...
I mean, in reading the documents, that would seem to be a significant portion of the case, right? Trying to say that basically because he was married, because he was married, she had an address outside the ward. The fact that they are married means he cohabitated outside the ward.
Well, I'm not even saying that. He said he didn't cohabitate. That's the important thing. What we have to show here is he wasn't residing at 1813 South Carpenter. Is it a reasonable inference to say that he may have really been residing at 20 North State Street? I think so.
That's what I got from your argument. You're saying that's not your argument?
No, that is my argument.
Okay. But you're saying that would be based on the sole fact that he was married.
Yes, he was married. His wife had a residence already established. He claims he's sleeping on the sofa of a retired school teacher, and his wife has a one-bedroom apartment downtown. And if you look at Dillaboo and some of the cases such as that, they look at factors as to where the family of the candidate is versus where the candidate says he's at. And the other factor is, this isn't a case where the person said, I had to move away from my job and I was in California for 6 months. That's why I was not cohabitating with my family. I had a temporary reason to leave my residence and go far away. This is a matter where the residence of his wife is minutes away from where he claims he's sleeping on the sofa. I think the key thing here is that without the approval of the landlord, without any lease, without any accommodation or agreement on the part of the landlord of the property, the owner of the property, he is a trespasser legally. He is not a resident. And if you're not a resident, you cannot put that on your statement of candidacy or other documents saying you reside at that address. And I think the other piece of authority I just want to address is the Mason case, where an issue was raised as to Rahm Emanuel's residency. Now there, the difference in that case from here is that Rahm Emanuel had a legal interest in the property he was claiming as his residence. He was the record owner of that property, although there was a lease to another person on the property at the time. This candidate has no legal interest in the property, 1813 South Carpenter. He's not an owner, he doesn't pay rent, he doesn't have a lease, and he did not have permission of the property owner. And DELP in its progeny made clear this, that the greatest weight must be given to objective facts. And when you look up the objective facts here, you have nothing more than a mail drop and a claim that he was couch surfing for 6 months on someone's couch. And if we're looking at the purpose of residency is to make sure that this person is a member of that community that he or she is seeking to represent. And when you look at the objective facts here, we don't believe that the record supports a finding that this person established legal residency for purposes of being a candidate. You can have residency for different purposes, but for purposes of being a candidate, the requirements as Delk sets forth were not met in this case. And we respectfully request the board, as the ultimate trier of fact here, to weigh the evidence and find the objective facts overwhelmingly say that residency is not existent.
Thank you, Mr. Mayor. Mr. Montevero?
So I will note that this appeal focuses on the findings of fact, and therefore this board must give due deference to the factual findings of the hearing officer who was there in person to attest to the credibility of all the testifying witnesses. And I will also note that unless the facts go against the manifest weight of the evidence, that this board must also give deference to the findings of the hearing officer. I will note that the findings of the hearing officer in and of themselves are very detailed. It is a 29-page written decision that makes clear that that the hearing officer considered and gave due weight to all of the testimony on both sides, that the hearing officer found credible the testimony of Mr. Sitchko and of the individual, the woman who allowed him to stay in her apartment, and that testimony established the residency at that second site in question, and that also took into consideration things like the fact that Mr. Sitchko canceled his electoral information from his previous address and then reinstated it at the new address, his intent to stay at that address. Moreover, I think the hearing officer clearly makes note that he considered all of the evidence that Mr. Neely cites to, gave it its due weight, and noted that from the beginning, the objector already had a very hard task because the purpose was to prove a negative, and that's already a very hard job. And on top of that, even though there were small indicia that may be circumstantial in perhaps putting some ground or meat into the argument that Mr. Sitchko was not a resident at that address, that it clearly meeting that burden of proving this negative, that those separate little indicia were not enough to rise to the burden, and therefore we would ask that this board give deference to the findings of the hearing officer and affirm his. Thank you.
Well, Mr. Nelly, this is, and I agree with Mr. Mondragon, this is an extremely detailed report from the hearing officer, and I think it's very good. And I certainly see where you're coming from. I do think that there are certain things that you have couched in certain ways. I don't necessarily agree with you. I think the candidate here was very truthful. He did state that there were times when he stayed at his wife's apartment, but you know, he stated that 1813 South Carpenter was where he was living at the time, and I think that it doesn't even matter if you're living there for the purpose of trying to establish residency for office. The fact is, I think the hearing officer made it very clear that he was living at the South Carpenter address. I think that there's was more evidence of the type of mail he received. The Wintrust Bank statements, a U of I Mercer Insurance enrollment offer, certain forms, the State Farm insurance policy renewal. There were other things aside from what you mentioned. I don't give much validity to the argument that Mr. Sitchko was a trespasser and not a resident. Gloria Herrera, was the landlord, but Martha, her sister, was renting the apartment, and she admitted that she gave him permission as the tenant to stay there. I just find the evidence tips in favor of the candidate here, despite all the evidence. And there was a lot of evidence introduced, including live testimony. Does anybody? If, okay.
I would agree. I just want to point to, on the record, the situation regarding the Whittier School, which is at 22nd and Walcott, is much closer to the Carpenter address than to a 20 North State address. And that, as my fellow commissioners know, I tend to go along with the hearing officer's recommendations unless there's been any showing of clear abuse of discretion. I don't see that here.
Mr. Westwood?
I find it a little unusual. No one's mentioned the fact that the evidence, the findings of the hearing officer show that when this candidate was living in an apartment in the 25th ward, he had to leave that apartment. I don't know why, and it doesn't matter. He gets married to a woman who lives a little outside of the 25th ward. They've purchased a home together in the 25th ward that's currently under renovation.
That's right.
And, you know, it has been well settled that residency law is physical presence and intent. So it's undisputed that this candidate was, at the beginning of the one-year period, a resident of the 25th ward. He left his apartment. I disagree with the hearing officer that Mr. Nally's case was about proving a negative. I think Mr. Nally's case had to be about proving where this guy then established a lawful residency. The candidate is claiming that it's at this apartment of a friend, that he's been staying there. He very well may have established a lawful residency. If not there, I would say the house that they purchased together, that they've never spent the night in because it's under renovation. But this is clearly a man, I believe, who his intent is that he is a 25th ward resident. Mr. Nally said the purpose of the residency requirement is to make sure that the candidate is a member of the community he intends to represent. This is a man who has lived in the 25th ward. When he lost his apartment in the 25th ward, he took action to, I believe, to try to not create a legal residency at his wife's condo outside of the ward because he wants to be a 25th ward person. That's who he is, and they've purchased a home there that they'll be moving into as soon as it's renovated. I think there's substantial evidence that he made a residency at this apartment with a friend. There's substantial evidence that he could also be claimed a resident at the new address of the house they have not yet moved into, but they own. I don't see any evidence in the record that he's actually established a residency at his wife's condo, other than his admissions under oath that, yeah, he does stay with his wife a few nights. But I don't think that's in and of itself. I agree with you very much.
No further comments. Is there a motion to deny the Rule 20 motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Now, we have two related cases here, so I'd like to take them up at this time. The first one is,
Thank you, members of the board.
are you going to wait for the decision?
Yeah.
The first one, is there a motion in 19 EB ALD-126 to adopt the hearing officer's report and recommendation?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And is there a motion in 19 EB ALD-117 to adopt the hearing officer's report that the objector has failed to appear and is in default?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Okay, the motion's been, the motion passes, and the name of Byron C. Lopez shall be printed on the ballot for the general municipal election. Now we will proceed with the next item on our agenda, consideration of hearing examiner reports and proposed final decisions. And we are continuing to group them. So, the first set of cases involve candidate withdrawals. The first case is George Brown versus Rachel Williams, 19 EB ALD-010, with a related case, 19 EB ALD-137, candidate for the 9th Ward. I'm sorry, that. And Ava Thomas versus Rachel Williams, 19 EB ALD-137, with the related case ALD-010. Again, Alderman for the 9th Ward. Is there a motion to dismiss both of these objectors' petitions as moot due to the candidates' withdrawals, which was filed on January 3rd, 2019?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and these cases are dismissed, and it is therefore ordered that the name of Rachel Williams will not be printed on the ballot for the municipal general election. The next couple of cases, the objector has withdrawn the petition each objector filed. Joan Hollingsworth versus Stephen McClellan, 19 EB ALD-079, candidate for Alderman of the 43rd Ward, and Clarence S. Deesh versus John Robert McDowell, 19 EB ALD-096, Alderman of the candidate for Alderman of the 46th Ward. Is there a motion to grant the objector's motion to withdraw in these two cases and dismiss the objectors' respective petitions?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the respective candidates in case numbers 19 EB ALD-079 and 19 EB ALD-096 shall be printed on the ballot for the municipal general election. We have two cases in which the objector has withdrawn her objections. Because there are other pending cases, in each of these cases, we are only addressing the withdrawals and not making any final decisions pending resolution of the other objections. The first case is Sally Hammond versus Trevor Joseph Grant, 19 EB ALD-028, with related case of 19 EB ALD-066, candidate for Alderman of the 1st Ward, and Jessica Santiago versus Mirko Limo Mike Z. Platic Jr., 19 EB-ALD-094, candidate for Alderman of the 26th Ward, with related cases 19 EB-ALD-054 and 151. Is there a motion to grant the objector's motion to withdraw and dismiss the objector's petition?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motions to withdraw the objections are granted in case numbers 19 EB-ALD-028 and 19 EB-ALD-094. Now, we have certain cases where the objections have been overruled. The first is George Brown versus Paul Collins, 19 EB-ALD-001, candidate for Alderman of the 9th Ward.
011.
I'm sorry, 011, thank you. The next is Samuel Louis versus Dwayne Truss, 19 EB-ALD-020, candidate for the 29th Ward. And there's two related cases there, 19 EB-ALD-022 and 071. Yolanda L. Hoskins versus Dwayne Truss, 19 EB-ALD-022, Alderman 29th Ward, with a related case of 020 and 071. Inglesa Tony versus Creative Scott, 19 EB-ALD-035, candidate for Alderman of the 24th Ward. Inglesa Tony versus Torino A. Sanzone, 19 EB-ALD-052, candidate for Alderman of the 24th Ward. Samuel Louis versus Dwayne Truss, 19 EB-ALD-071, with related case 19 EB-ALD-020 and 022, candidate for Alderman of the 29th Ward. Renee G. Owens et al. Versus Berto Aguayo, 19 EB-ALD-099, for Alderman of 15th Ward. Rashida N. Tucker versus Gabriel Camonte, 19 EB-ALD-111, candidate for the 5th Ward. Mildred Hare versus Ebony D. Lucas, 19 EB-ALD-120, candidate for Alderman of the 4th Ward. In each of these cases, is there a motion to adopt the respective hearing officers' reports and recommended decisions, overrule the respective objectors' petitions, and enter final decisions in favor of each of the aforementioned candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the motion to adopt the hearing officers' respective reports in the aforementioned cases is granted, and it is therefore ordered that the names of the respective candidates shall be printed on the ballot for the municipal general election. We have Chayaka Hughes versus Shelley Quiles, 19 EB-ALD-133, with a related case, ALD-115, candidate for the 5th Ward. Is there a motion to adopt the General Council's report and recommendation and enter a default judgment against the objector? There is a pending case here, and that is 115.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motion to adopt the General Council's report and recommendation is granted in this case. We now have certain cases in which the hearing officers assigned to the respective cases have determined that the objector's objections should be sustained and recommend that the respective candidates' names shall not be printed on the ballots. They are as follows. Leroy Davis versus Julius Modaliste, 19 EBALD-018. There is a related case, 038. Candidate for Alderman of the 21st Ward, Wilfredo Gonzalez Jr. versus Renee Tex Chavez, 19 EBALD-023, with a related case of 026, candidate for Alderman of the 31st Ward, Sally Heyman versus Justin Tucker, 19 EBALD-025, related case 19 EBALD-067, Alderman of the 1st Ward, Joshua Bird Martinez versus Renee Tex Chavez, 19 EBALD-026, with a related case of 023, candidate for Alderman of the 31st Ward, Marcel Bright and Darrell Lenoir versus Sherry Bowling, 19 EBALD-030, with a related case 036, candidate for Alderman of the 8th Ward, Linda J. Bell versus Sherry Bowling, 19 EBALD-036, with a related case 19 EBALD-030, candidate for Alderman of the 8th Ward, Deborah Parker and Geralda Morgan versus Julia Modaliste, 19 EBALD-038, with a related case 018, candidate for Alderman of the 21st Ward, J.G. Ramirez versus Justin Tucker, 19 EBALD-067, with a related case 025, candidate for Alderman of the 1st Ward, Grace Contreras, Michael Anthony Rodriguez, William Anson Sr. versus Francisco Nunez Jr., 19 EBALD-073, Alderman of the 12th Ward, Rashida N. Tucker versus Shelley Quiles, 19 EBALD-115, with a related case ALD-11133, Alderman for the 5th Ward, Nathaniel Moore versus Sharon Cy Lewis, 19 EBALD-116, candidate for the 7th Ward, Jessica Anderson and Jessica Terry versus Kennetha Hill, 19 EBALD-122. There is a related case 147, candidate for the 20th Ward. And Kevin Bailey versus Kennetha Hill, 19 EBALD-147. There is a related case, ALD-122. In each of these cases, is there a motion to adopt their respective hearing officers' recommendations, sustain each of the objectors' petitions, and enter a final judgment against each of the respective candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the respective hearing officers' reports and recommendations are adopted. In the aforementioned cases, the objectors' petitions in each of these cases are sustained. It is therefore ordered that the names of each of the aforementioned candidates will not be printed on the ballot for the municipal general election. Mr. Lester, is that a complete?
That should do it for today.
Okay.
Do we have any requests for public comment?
Yes,
Yes.
we do.
Mr. Blake.
Thank you. Sorry. He'll bring the podium over.
Thank you.
There is one request for public comment. George Blakemore. Mr. Blakemore, good morning. How are you?
I'm an angry black man because of what I've heard here today concerning his hearing office and particular this Catherine Brown case. All of you who are sitting one of these birds are politically connected. And that's how your decisions are being made. Your politics. Your politics. Before they had Lena, and he would get all kind of contracts for his law firm. So I'm just not a popped up citizen. Mr. Blakemore is unique. He connects these dots. Go to these public meetings. He listens and he learns and he watches. So again, each one of you here, you all up here are part of a corrupt system called the Democratic machine. The cesspool is not in Washington, D.C. It's right here in Cook County. So the name comes up. Who's challenging these people that want to be candidates? The political hacks. For years and years and years and years. And when Reverend Brown said, show me one, she made points, and you say, well, we understand this, but this is the law, and we're mandated to go by the law. You are mandated, but you don't go by the law. You make the laws, which you shouldn't be able to do. I came as a concerned citizen. I was here before Jonathan got here when Lane and me was the chairman of this, the city. Known for waste, fraud, and abuse, and corruption. The egregious things that goes on at the Board of Election. They try to keep me off the ballot. They tried to keep me off the ballot, but I prevailed. And I got a lot of votes. But they said I lost. The candidate got 95,000. That's more than any city already incumbent commissioner. All this is hooked up with corruption.
Okay,
So,
can you just keep your voice down?
that's when I told you, when I presented myself as an angry black male of the system. When I pick up my newspaper and I see the connection with the Board of Election, with the political hacks, I have to connect the dots. And it's disgraceful. It's unacceptable. It's bad public policy. So when you're angry, you speak loud. So I'm still angry, but I'm speaking softly. It was an egregious act that occurred here at the election board with Ms. Catherine Brown and with others. And it continues until the citizen, the public comment. Nobody else is here but me. And if I didn't come, you wouldn't have any public comment. And then I did sign up for the next meeting that's going to go on after this. So, thank you.
Thank you.
And one kill. On the mouth.
The decision forms ruled upon today have been signed here today in open session. They will be served pursuant to section 10-10.1 of the Illinois Election Code. For parties who were not present today, they will be deposited today into the U.S. mail.
Is there a motion to recess, Mr. Lasker? I believe it's to January 11th, 2019,
Yes, in the afternoon,
in the afternoon, and we will
tentatively 2:30.
post, yeah, we will post the time and date and the agenda very soon. Is there a motion to recess?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Thank you.